Well, welcome to Micro Lecture 6.1. We're going to be talking just very briefly about the Constitution. And in 5 minutes, I can't cover what, of course, I would normally cover in a 16-week course if you were to take constitutional law, and only that course would touch just some of the history of the Constitution. So this is such a broad topic, I kind of have to pick and choose a few things I think you would be less familiar with after giving you a little bit of a background. And I did want to also, for your education, touch on the North Carolina State Constitution, which, even though most of you listening to this will be residents of North Carolina, you probably have never read or heard about. So, jumping in here, where does the Constitution come from? Well, in 1787, in Philadelphia, there was a constitutional convention. It was initially called just to kind of amend the then Constitution, which was called the Articles of Confederation, but gradually when they sat down to it, the delegates, with some opposition, decided that they were going to draft a whole new Constitution. So in 1787, there was a committee called the Committee of Detail that adopted something called the Virginia Plan, by and large. That was the primary basis of the structure of it. And they wrote our Constitution as it exists today. There was then a fight in America between 1787 and 1789 as to whether the states, and there were 13 states at the time, it used to be the 13 colonies, and you had 13 states, would ratify this. So those who supported ratification, and they were led by the what became known as the Federalists, went around, particularly to the big important states. And the big important states were Pennsylvania, New York, Massachusetts, and Virginia. And they really fought hard to get those four states to ratify. The smaller states, including North Carolina, were important, but not enough to really derail the process. By 1789, the Federalists had convinced enough people, enough states, that it was ratified. And for a very brief period of time, North Carolina actually existed outside the United States. We didn't ratify till a little bit later, after enough people had ratified that it came into effect. The Constitution since 1789 has been amended 27 times. The most important for our purposes is the Bill of Rights, which are the first 10 of these amendments. And we'll just briefly talk about those, focusing a little bit on your general rights, but also a little bit more specifically on your criminal rights, since this is a criminal justice course. So you have, of course, your First Amendment rights. Those are your rights to assemble, your rights to petition or for redress of grievances, the right to practice your religion and not to have an established religion. We have our Second Amendment, which is somewhat controversial, which says you have the right to bear arms. Now we're starting to hit some of the ones coming up that are important for criminal law. You have the right against unreasonable search and seizure. That's your Fourth Amendment right. And we talked about this in that last chapter. You have the rights against self-incrimination, not to be a witness against yourself, and the right against double jeopardy. Those are Fifth Amendment rights. You have the right to a counsel. Initially, that just meant you could hire one. You have the right to call witnesses, and you have the right to confront or cross-examine witnesses. Those are Sixth Amendment rights. You have the rights against cruel and unusual punishment, although, and this is a significant problem. What does cruel and unusual mean? Is an execution cruel? Is torture cruel? Is solitary confinement cruel? What is cruel? And of course, kind of a general one, you have a right to due process of law, something we'll talk about a little bit later in the course as well. Now, one of the things I wanted to bring up here, and I think there's a couple points. I'm going to talk about this. I'm going to talk quickly about North Carolina, is when the Bill of Rights didn't apply. We tend to think, well, I'm an American. I have my First Amendment rights, say, to worship how I choose, or I have my Second Amendment rights to own a gun, or I have my Fourth or Fifth Amendment rights, or my Eighth Amendment rights against cruel and unusual punishment. But initially, you had those rights, but only if the federal government was trying to violate them or take them away from you. So the federal government, if we took the First Amendment, and here's one of the examples, couldn't establish a church, couldn't collect taxes, take the money, and pay for the salary of ministers or priests or rabbis. But that was done by the states. There were several state churches, I believe as late as 1833 in the United States, some of these were in New England, that routinely collected taxes and had state-supported churches. Um, States also suppressed speech. Yes, the federal government was prohibited from banning speech, whatever speech meant, and that's been a constant fight. But the states can and did censor speech. So, for example, as late as 1859 in the United States, the state of Virginia and South Carolina routinely went to the U.S. mails, seized newspapers because newspapers were often printed in different cities and then delivered by U.S. mail, seized them and burned them, didn't deliver them. Only gradually did the Bill of Rights become federalized, and it's particularly with the passage of the post-Civil War amendments, the 13th, 14th, and 15th, and then their gradual interpretation by the Supreme Court in a particular way, that they become the rights everybody enjoys, whether it's the federal government misbehaving or the state governments. So what does the Constitution mean? Well, it's a very short document, and words can be interpreted in many, many different ways. Now, these are very broad terms and very inexact, but if we talk about a conservative interpretation of the Constitution, it's often called textualism or literalism, sometimes originalism or strict constructionalism. And in the next few chapters, we're going to talk about those. The liberal interpretation, sometimes called the living Constitution, is significantly different in a lot of ways. Basically, I have to say that the Constitution is what the Supreme Court of the United States says it is, and that means it's very important who sits on the Supreme Court, because it's their opinions that matter. I might have an opinion, you might have an opinion, but if 5 of the 9 justices on the court have a different opinion, they win. The last thing I want to talk about very quickly, as I said at the beginning, was the North Carolina Constitution. Now, we've had several constitutions in our history, going back to the 1770s. The most recent one kind of started in the late 1960s, where it was clear that we needed to kind of clean up an older constitution we had. And in 1971, we drafted, and it came out of the General Assembly, I think with 1 dissenting vote, as I recall, and then it went to the people, and the people voted for it. It won by a couple 100,000 votes, I believe, or more than 100,000 votes. So it's our current Constitution. The differences that you would notice if you looked at it was that we put our Bill of Rights in the front. So we call it the Declaration of Rights, not the Bill of Rights, and it's in Article 1 of the North Carolina Constitution. It's a little bit longer. The rights are a little bit more extensively talked about. An interesting one is you're supposed to have free higher education in North Carolina if practicable, which raises an interesting question what practicable is. And certainly it's typically not a free education for higher education. The North Carolina Constitution certainly applies, but of course if it conflicts with the U.S. Constitution, it loses. So I think the way to look at this is the federal Constitution is the absolute floor of your rights. You can't go any lower than that. If a state tries to take away a right, it loses. But, and this is an important point, the state can give you more rights. So if the federal Constitution is the floor, your state Constitution is the ceiling. There are a few parts of the North Carolina Constitution of 1971 which are invalid. One of the things that was in some of the provisions was disqualification for holding office if you were an atheist, if you didn't believe in the Almighty God. That's unconstitutional. We also used to in North Carolina not tax the sale of Bibles. Every other book were taxed, but if you bought a Bible, there was no tax on it. That was eventually stopped. There's the literacy requirement. This was a tool used against African Americans primarily. That's been struck down. We also had a provision that said that you could have an execution for rape, arson, or burglary. The Supreme Court of the United States in a decision has said no, the only crime for which you can be executed by the states is homicide, murder. And finally, we have a provision in the North Carolina Constitution which was voted in by the majority of North Carolina voters, making it illegal to have same-sex marriage in North Carolina, and the Supreme Court of the United States struck that down. So if there's a conflict between North Carolina and the Supreme Court's going to win. All right, we will pick up with the next lecture, which is 6.2, whenever you want to hear it.